next appeals are 14 and 15, People v. Baldwin and Ba.
Good afternoon, Your Honors. Cleo Weiss on behalf of Dakota Baldwin. May I please reserve 2 minutes for rebuttal?
Yes, 2 minutes.
Thank you.
In this particular case, isn't Mr. Baldwin now released?
That is correct.
So why isn't the case moot?
So this case is not moot, and I would submit it's not moot for 3 reasons. If this court disagrees with me on those reasons, I would also submit that an exception to mootness is applicable here. But the 3 reasons that I would submit that the appeal is not moot, the first deals with correction law, section 201, subsection 9. This is a law that was repealed in April 2022 of this year, and it's a law that required that parolees pay a fee of $30 per month for the pleasure of parole supervision. And it was applicable to Mr. Baldwin at the time that he was paroled, and it's my position that if a court determined that his sentence of 2 to 4 years is unduly harsh and severe, and reduced it to 1.5 to 3 years, he would be entitled to a return of those funds that he had to pay during that year when he was on parole supervision. So that's one reason. There's an economic injury to Mr. Baldwin that I think keeps this from being moot. And then there's 2 reasons having to do with the continuing consequences, concrete consequences of the length of a sentence, even after a defendant has finished serving his sentence. And one of those is specific to New York. It has to do with Sandoval compromises, which is when the people are allowed to cross-examine a defendant who chooses to exercise his or her right to testify. And the compromise is where you don't get to go into the details of the conviction. You don't necessarily get to say what the conviction is, but you can ask a defendant, were you convicted of a felony? And oftentimes, the people are allowed to use as evidence the length of a sentence as a way of indicating to the jury the severity of a prior conviction. So the length of a sentence has evidentiary value to the people in a Sandoval context, and therefore has a continuing injury to any defendant who might sustain, a further prosecution. And the third area in which the length of a sentence has a continuing consequence has to do with, again, further prosecution. It may be considered in a bail determination, and it would certainly be considered in a future sentencing proceeding. Judges who are paying attention to the theory of deterrence, many judges think that, there should be progressively longer sentences. And even if you're not subject to second felony offender or a predicate felony sentencing, the length of your first sentence often informs what the length of a subsequent sentence should be. So there's 3 reasons I would submit that the length of Mr. Baldwin's sentence, one very concrete to Mr. Baldwin having to do with the fees he paid, and 2 that would be as to any defendant who is seeking to have the length of their sentence.
What's the exception you claim if we disagree with you?
If Your Honors disagree, this is a significant and important, it's a novel question about the exceptional circumstances standard used by the 3rd Department, and significant and novel questions not been previously passed upon. That can be an exception to mootness. This case is fully briefed before Your Honors.
What about likelihood of reoccurrence here in the 3rd Department?
Likelihood of reoccurrence, this standard is no longer used in the 3rd Department based on my understanding, but it is still employed from time to time in the Appellate Division 1st Department and in the appellate terms, and some county courts are often not publishing their appellate decisions when they sit as appellate courts, but this is a standard that is used by county courts as well. So there is some chance that it would occur, whether to Mr. Baldwin or not, but I think that this is a significant question. It's a question this court has not ruled, has not addressed the appellate division's sentencing power since 1992 in Delgado. And this is a novel issue that is ready for this court to decide.
But regardless of what they said the standard was, they did look at the correct factors as we laid them out. So what are we to do about that?
Well, so I think the standard of review is important, and I disagree with opposing counsel that the extraordinary circumstances or abuse of discretion test is a test. I think it is a standard of review, and I think we need to take the appellate division at their word when they've been repeating this standard over and over again since the 1970s, that that's what they're doing. They're not actually conducting.
They told us what they were doing. They were looking at defendant's mental health, his substance abuse struggles, criminal history, the nature of the assault. They were doing what we asked them to do. They might have mischaracterized the standard, but in their analysis, they actually use the factors that we said are appropriate.
So one thing that I look at in the decision in Baldwin is that the Third Department writes, the record reflects that the court reviewed the pre-sentence investigation report, and then going into the details, as Your Honor said, of what's in there. And that's abuse of discretion review. They are looking at what county court was doing and kind of giving their stamp of approval to it.
Isn't that really what happened in Delgado? I mean, it's almost the exact same language, right? We read the appellate division statements that the sentencing courts did not abuse their discretion to mean that the appellate division did not find the sentences unduly harsh or severe under the circumstances. And that's pretty much the same language you have in the appellate division here in Baldwin. Why doesn't the same rule apply that we applied in Delgado?
So I think there's a couple important differences, and one is the extraordinary circumstances language, which this court did not address in Delgado. And then I would also point out that the Third Department standard has been used since the 1970s. It's an entrenched standard that they repeat over and over again. And I mean, Delgado is a decision that is has some internal contradiction. On one hand, they say the appellate division should make this decision without deference to the trial court, and then they say, but we read this language to mean that they're actually conducting unduly harsh and severe review. And I think Delgado desperately needs to be clarified because, you know, with the Third Department, we don't have just a one-off case using abuse of discretion review. It is every single case that they've been repeating this standard of review. Meanwhile, Delgado says that's not the standard of review. And in Mr. Baldwin's case, we see that the actual review they're conducting, the way they've written about it in the decision, truly is an abuse of discretion review. And I think that Delgado needs to be reinforced and it needs to be clarified. You know, every jurisdiction has a mechanism for ensuring consistency in criminal sentences. Some jurisdictions use sentencing guidelines, whether mandatory or advisory.
So in the very least, you believe that the courts it needs to be clear to the courts that they can review the sentence regardless of what happened at the trial court level, that they have a right to review it without extraordinary circumstances in the interest of justice.
That's correct, Your Honor, and it's not just a right, but it's a duty, because the legislature has set unduly harsh and severe as a standard, and in New York State, our legislature, our system is that we create consistency in sentencing from county to county and from judge to judge through appellate sentencing review.
So you're saying, in the very least, that clarification is valuable here?
Yes, Your Honor.
Going forward?
It is valuable because the legislature has vested our appellate divisions with this power, as in Delgado, without deference to the trial court, to make a plenary decision, to review, all of the factors de novo and to decide.
Why should we be concerned in that regard, given that they did a full sort of examination of all the circumstances that would be appropriate for them to review?
Well, because, Your Honor, they did not review it with the correct standard of review in mind. If they were to go back and look, is Mr. Baldwin's sentence unduly harsh and severe, as opposed to, hey, are there extraordinary circumstances here, or did the judge abuse his discretion, you could well reach a different result.
Do you read in the decision that they were deferring to the lower court's findings with respect to the factors that they were looking at?
Yes, Your Honor, that is how I read this decision, where they are basically reviewing what county court did and did not review, and then, concluding that there is no abuse of discretion.
Okay, thank you.
Thank you.
May it please the court, counsel, Zach Persicini on behalf of the County of Chemung. I would like to start by addressing some of the cases. I know we talked a little bit about how the Third Department may have started to change what is perceived as their standard. And I know in the reply brief, appellant cited a number of cases from 2021 and 2022 where the Third Department is no longer using that extraordinary circumstances language or abuse of discretion language. I would submit that if you delve further into those cases, I think that actually makes our point a little bit. If you delve further into those cases, in each of those cases, so Streeter, Sanders, Machia, and I
So would
believe
you start with the
Lancaster.
premise that the case is moot or not?
Of course, yes,
And then you would go as to whether there are exceptions to the mootness doctrine?
absolutely, yes. That's absolutely correct. I would talk about those four cases, Machia, Streeter, Sanders, and Lancaster, four of those that were cited in the reply brief. Each of those cases cites an underlying Third Department case that talks about extraordinary circumstances or abuses of discretion. which goes to our argument that this is more of an argument about semantics, that we don't like the term extraordinary circumstances. We're fine if we were to just talk about age, criminal history, nature of the crime. Once we term...
Let's stay with this mootness issue, though, more expressly in terms of what counsel has argued. What about this argument that there is an economic injury? And that's at least one ground for why it's not moot.
I do not have a great answer for that. I would just focus on, I guess I would turn to the fact that maybe it would not be moot. I do think this is an important issue, and there may be a need for clarification, similar to the decision in Romero, this court's decision in Romero, that sort of told the lower court, the appellate departments, hey, maybe make sure you use the correct standard, or maybe make sure you focus on more recent case law when discussing weight of the evidence. But we still see that you use the correct analysis in your understanding, despite using maybe an older standard. Here, that could, I guess, be the argument, is that even if this court were to believe that the third department used an incorrect standard, or maybe extraordinary circumstances shouldn't be used, I would submit that the analysis performed by the third department was correct, and there would have been and would be no need.
How do we know that? How do we know that the analysis it would have been the same had they not used extraordinary circumstances and instead said unduly harsh or severe?
That's a question. I actually want to talk about that in particular because similar to Romero, not to just go back to Romero, but similar to Romero, the court noted that, say the third department in this case did not talk about anything, they just said, we do not find the sentence to be unduly harsh or severe. That would have been the end of it. They could have summarily just rejected it, similar to Romero. The second department often does that. The second department often does not get into any analysis. That is where I guess there's the presumption that the appellate judges throughout the state understand the law, they understand...
It seems to me there's two things, though. One is what's the set of ingredients you're looking at, and the other is what is the recipe, right? And so to say, I looked at, the recipe for ice cream, and it's vanilla and cream and milk and salt and sugar, and you also looked at that same thing, but if you put it in an ice cream churn and I bake it, we're going to wind up with very different things. And so when you say, well, they could fail to tell you what the ingredients they looked at are, but they told you what the recipe is. That is, they put it in an ice cream churn. Well, if they wound up with ice cream and we've already said we don't need to know what the ingredients are, that's one thing. But on the other hand, saying that we've both looked at the same set of ingredients and it doesn't really matter how we characterize the recipe doesn't convince me.
Throughout, I guess I would submit that throughout the state, we're never going to have like a set standard throughout the state, or a set test, I would say.
Well, isn't that what we try to impose on people?
Try to, yes. And there is...
This is the Court of Appeals. We're not just in this area, in every area. We're trying to create a uniform body, and we use words, and we try to make sure that those words are followed. And if somebody deviates from those words, we're worried about that.
And that is where I would say there is the discretion. That's left to the discretion of the appellate departments. And each appellate department is going to have different judges that are going to change. They're going to have different attorneys bringing different arguments. And that is where on each individual
Is the
case...
standard?
Standard would never change.
Okay, so you would agree, for example, that one appellate division department couldn't say, our test for interest of justice reduction of a sentence is, if the sentence is illegal, then we'll reduce it, but otherwise we won't. That would be an inappropriate test.
Can you repeat that?
Sure. Suppose a department said, our test for interest of justice reduction of a sentence is illegal sentence. Only if a sentence is illegal will we reduce it, otherwise we won't. Is that, and some other department has a different standard. Can we correct that?
I guess I would argue that that is the discretion of that appellate department, and that is, so in the matter, it's a matter of discretion analysis in the interest of justice. Now, that would be an extreme, but I would submit...
I tend to
yes,
make my hypothetical something.
I would submit that that would be in the appellate department's discretion. The appellate departments throughout the state have talked about this extraordinary circumstances. The second department has cited that, fourth department, first department. But every department looks at the same factors. And I understand that we label things extraordinary circumstances. Some departments label them mitigating factors. That's another term. In fact, in this case, mental health was termed a mitigating factor. So my argument would be that if it's a mitigating factor in one sense and it's an extraordinary circumstance in another, I don't know that those are different things. We might not like...
Of course, in the SORA context, we consider those very different things.
Yes, understood.
Those
Yeah.
exact same words.
But that is not the case here, I would submit.
Counsel, I'm more concerned about the abuse of discretion language. That suggests, and your adversary suggested, that maybe they were looking at it with the wrong eye. In other words, they were looking at the right ingredients, but they were baking it instead of putting it in the ice cream maker. How do we know that that didn't happen here?
We go back to the presumption that the appellates would know the law, they would do the right analysis, but I would also go to the fact that in this particular case, they did talk about how the county court reviewed pre-sentence investigation. They talked about the factors. They also did talk about how they understand that this is the maximum sentence for an attempted assault second, which would give credence to the idea that they are looking at the factors we consider, which includes the type of sentence, the crime, the nature of the crime. Again, this was a reduced felony, so it was actually an assault second, reduced. He pled to an attempted assault second. So we know that they're not just relying on the pre-sentence investigation. We know that they're also looking at the sentence, the nature of the crime in this case. And again, I would submit the appellate department, almost every case probably, criminal case probably has this type of argument that a sentence was unduly harsh or severe. They've handled hundreds of these types of arguments, hundreds of these types of decisions. If we say that they did not have the right analysis in this particular case, then I guess we would be questioning whether they've had...
You don't disagree, do you, that the whole thing would be so much simpler if it didn't say abuse of discretion? That wasn't necessary language in order to resolve this excessive sentence question, was it?
I guess it would not be necessary language, but then you get to the point where would we rather have a world like the second department often does, where they just don't give any of their analysis? We have no idea oftentimes what their thinking is or what type of factors they're looking at. They will just simply use a line that says, we find the sentence is not unduly harsh or severe. I understand Your Honor's point about extraordinary circumstances. Maybe if they just talked about, we looked at his age, his criminal
So
history.
maybe we should say, you've got to explain. Maybe that resolves the concern you've raised.
I don't disagree with that. I think that would go towards my previous infatuation with the Romero case. That talks about essentially that point, that maybe we see that they did the right analysis, but maybe we should remind them not to use extraordinary circumstances. That language is maybe not necessary in this case or future cases.
Thank you.
Thank you.
So, Your Honor, using an incorrect standard of review, it distorts what advocates argue for the Appellate Division 3rd Department. It distorts the analysis that court undertakes, and it distorts results. I did look at data from 2012 to 2021, and if this court pulls every harsh and excessive sentence, every modification by looking at the decretal paragraphs, and then kind of does the percentages with number of criminal appeals decided in each of those years, what I found is that the first department modifies 1.9%, the second department modifies 1.5%, the third department modifies 0.7%, the fourth department modifies 2.1%. So we've got the third department modifying drastically lower amounts of criminal sentences, and that disparity through the departments is harmful to appellants within the third department. And I think that...
And do you posit that's because they're applying the wrong standard?
I do posit that it's the wrong standard, and I believe the extraordinary circumstances standard is a deferential standard. And if you look at the fourth department's language...
But then wouldn't it be zero? I mean, the fact that they are reducing sentences, they are doing an analysis, sometimes they are doing it correctly. I mean, how are we to presume, because I think you're presuming that they're always doing it wrong because they're using the wrong standards. So what about the fact that when they do it right?
Well, I think they are always doing it wrong, and when you do it wrong and when you apply the wrong standard, you still find a couple sentences that are worthy of modification.
When they find those harsh and excessive sentences in those small percentage of cases, are they still saying in those cases that was an abuse of discretion, or are they saying they were unduly harsh and excessive?
In the cases where they do modify, those few cases, it's 1 to 3 per year that the third department modifies, they often go into a more in-depth discussion about why they're doing it, whether it's the age of the defendant or certain characteristics.
So is it your concern that if they were clear that they do in fact have the power, they would use it more often?
That is my contention, and returning to what the fourth department says, they repeatedly have to remind the people that that's not the standard they use. And I think it's telling that the DAs in the fourth department want to use this third department standard. They keep repeating it in their briefs. They want it because it's a more restrictive, more deferential standard.
But in
And they-
those cases where they do exercise it, are they using the correct language or not? I'm still confused about that.
So I apologize, I don't have the name of the case off the top of my mind, but there's one case where Justice Aarons dissented from a modification of sentence, and she said, well, I don't find extraordinary circumstances. Now, I don't think the extraordinary circumstances phrase showed up in the majority opinion, but they were just discussing whatever it was that they found to be extraordinary circumstances. And I agree with opposing counsel that when the third department does modify, they are looking at the same sorts of factors that all courts look at when we consider whether to modify sentences or not. But when you don't have the right standard of review, you don't analyze the factors correctly, and you end up at different results. And the data shows that the third department ends up with different results. Thank you.
Good afternoon. I am Lauren Jones from Legal Aid Society of New York City, here on behalf of appellant Mamadou Ba. May I please request 2 minutes for rebuttal?
Of course.
Thank you. So this case presents another question about the excessive sentence power. It's another case in which the intermediate appellate court is applying an incorrect standard when exercising their excessive sentence power. Here, the appellate term, First Department, treated the fact that the sentence was legal and negotiated as a bar to review.
Well, I'm going to stop you there, because they also said we perceive no basis for reducing the fine. If they had stopped there, would that be okay?
If they had stopped there, I think there would still be a little bit of a question about whether or not that means that they performed a discretionary review, but because they are not required by statute to elucidate, I think that there would be less of a problem than what happened here, which is that they continued on and did give their reasons, which, to read the second sentence of this
Right, but
sentence
can't we
decision-
read it also as the second sentence being in addition to the first sentence, as opposed to the second sentence being drawn from the first sentence? You know, you're saying that they said this first sentence, and then they're explaining it. But why couldn't they say the first sentence, they've done their analysis, and they're adding the second sentence? I mean, I think that's just as reasonable an interpretation as yours. Am I wrong?
Well, we argue that the fair reading of the two sentences is that the second sentence is the rationale for the first, if the second sentence is an addition, it's essentially a non sequitur in a part of a decision that is only 2 sentences long. I mean, that requires essentially ignoring that second sentence, and it's irrelevant. I mean, they're saying the sentence was legal in a case where no illegal sentence claim was raised, and they're saying that he received the sentence that he bargained for in a case where there was no claim that his plea should be withdrawn because he didn't receive that sentence.
But I could say the same thing about that, right? I could say the second sentence, the first sentence is extraneous then. If what they were really saying that it was a negotiated plea, they don't need the first sentence, right? So the fact that it's there might indicate that they've done a separate analysis.
I'm sorry, can you repeat that question?
I'm saying that they might not even need, if it's just an explanatory sentence, the second one of the first sentence, they wouldn't need the first sentence. So I'm saying it's just as reasonable to say, they said the first sentence, right? We perceive no basis for reducing it, stop. we did that analysis, and by the way, it's also a negotiated sentence.
Well, I think that this, because there were no issues raised in the briefs about that, the two issues in the second sentence, I think there would be no reason for the court to have included that in its decision if it were not the explanation. And I think if we have doubt about what the court meant here, we can look to its other excessive sentence cases from both before this decision and after, where they repeatedly say that a defendant who is sentenced in accordance with his bargained for plea should not now be heard to complain that
So
he
is
received
your
what he bargained.
argument that clarification is appropriate here?
Yes, Your Honor. Clarification is appropriate.
If we clarify, what would the remedy be? What do we do with the case?
The remedy would be a remand to a remittal to the appellate term, First Department, to either to explain their decision or to redo it applying the appropriate
So if we
standard.
send this back and then they put in a now line that says this sentence is not unduly harsh or excessive, that would be enough?
Yes, Your Honor. Yes,
And
Your
do you have
Honor.
any idea, I would assume excessive sentences claims are fairly often made in this appellate term?
I think they are fairly often made, I think less so because the sentences in the appellate term aren't
In
as long.
any case where they use this type of language, that would go back for them to put in an unduly harsh and excessive standard.
I think the ones that are currently at the stage, where this court has not denied leave, that yes, which I think would be a fairly small amount of cases. I would also point out that the danger of this case, the reason why it really needs clarification is because it's not just this particular case, it's everybody who's looking at what the appellate term First Department is saying in excessive sentence cases, and when they say that the sentence, it will not be reduced, period, it's legal and negotiated, that is sending a message to the litigants who are preparing to bring these claims to this court. The other part of this decision is that the intermediate appellate court shouldn't have been considering the fact that it was legal or that it was negotiated at all. The legality of the sentence is unquestionably irrelevant to whether or not the sentence was excessive, and the negotiation itself should not have been
But
considered
the
either.
court does have a responsibility not to let illegal sentences stand, correct?
Yes, but if the sentence had been illegal, that claim would have been brought to the court, and the way that it's written here is not, the sentence, even though legal, is harsh and severe, is not harsh or severe as the statute is written. Instead, the way this is written is much more of it's giving the rationale. Because it was legal, we're not reducing. And the negotiation itself also should not have been considered here.
But why not? Because this is a fine, right? So it's not like a sentence. And the negotiation may demonstrate that there was a discussion about what a defendant could afford to pay. So, I mean, is the fact that it's a fine different at all in your analysis? Does it make a difference?
I don't think so. The fact that it's a fine, especially here where it's clear on the record that the other option was 3 days of community service. I think it seems that Mr. Baugh was more willing and interested in taking a perhaps unduly harsh fine than give up 3 more days of having to lose wages, to not be able to go to his job, to not be able to take care of family members, when he had already gone back to court. This is the 7th time he had come to court on this case. I also think that there are other reasons not to consider the negotiation. For example, there's just no way to evaluate the negotiation on the record.
Do the parties stand on equal standing?
No, the parties do not stand on equal standing. There is an unequal bargaining power here. I think it's really obvious here where the prosecution decided not to prosecute these cases anymore within a year of Mr. Baugh's sentencing. I mean, it really shows the great power that they have.
Thank you, Ms. Jones.
Thank you.
Good afternoon, may it please the court. Megan McLaughlin for the people. The appellate term acted well within its discretion here in affirming defendant's sentence of a $500 fine for illegally offering to sell counterfeit luxury handbags. In its decision to affirm, as this court has already pointed out, the court stated that it had perceived no basis for reducing the fine. That statement alone demonstrated that the court had considered and rejected defendant's arguments to the contrary.
Why was it, what is the significance of, if anything, of them saying legal and negotiated, using those words?
So, as Your Honor has already pointed out, the court has a duty to affirm and uphold a legal sentence. So, it's the people's position that in terms of when they reference the legality of the sentence, that the court was covering its bases and explaining that it's affirming a sentence that is legal, so no problems there.
Was that one of the defendant's arguments, that the sentence was illegal?
I'm sorry, Your Honor?
Was that an argument that defendant made on that appeal?
No, Your Honor. The argument made on appeal was that it was excessive, and in affirming the sentence that the court had imposed, the appellate term mentioned that the sentence was legal, and it was affirming that sentence.
Is that something that this appellate term regularly does? Do they always include a little extra info about the legality of the sentence?
I believe occasionally, and just to be clear, it was not necessary in this decision for the court to say that.
In particular, do they do that when there's no excessive sentence claim and no claim that the sentence is illegal?
I don't have an exact number of the amount of times that the appellate term has made that distinct statement. However, it was not necessary to the decision in the same way that it was not fatal to the decision. There is no indication that the appellate term relied on that fact, and this court need look no further than the previous decisions by the appellate term that does in fact reduce legal sentences. So the court clearly does not view it as a bar, as defendant claims, if its prior decisions fly directly in the face of that claim. Now, in the
What
term...
about the claim that there's rarely an exercise of the right to reduce sentences, as evidence that they don't know that they can?
As counsel actually already pointed out, the sentences in the appellate term are generally lower than in the appellate division. So that could be one reason why it's less often the case that they are being reduced. However, there are three distinct reasons why this court could be confident and should be confident that the appellate term knows exactly what its power is and is utilizing it to the full extent. First, the language of the decision, which we've already discussed, is that the court perceived no basis. That indicates that the
Why
court...
isn't that just a conclusion?
Well,
Conclusion.
it's a conclusion based on its analysis.
Yes, and the analysis is not in that sentence.
Yes, and the CPL nor this court has never required the appellate term to explain its
No, but
decision-making.
but the panel added its own words, right?
Yes, the appellate term then went on to explain two undisputed facts about this case.
In the same paragraph with, we perceive no basis for reducing the fine.
Yes, but there is no evidence, and this court should not take that sentence to believe that the court, for some reason, took those two factors and...
Isn't that the paragraph topic sentence, and now you're explaining your conclusion?
Even if the court did consider the negotiation aspect, that it's the people's position that that would not have been improper. And in any event, the court did not need to, or at least up until this point, this court has never required the appellate term to explain every single reason why it made the decision it did. And moving on to the second reason that this court can be
But we do
confident...
require the correct standard to be applied.
I'm sorry, Your Honor?
We do require the correct standard to be applied.
Absolutely, and here the appellate term
And
did...
so if the paragraph, if we disagree with you, the paragraph reveals that they've applied the wrong standard, that's what we conclude. Do you agree that this goes back, it gets remanded for them to either explain? But if we conclude that they have applied the wrong standard, I assume what we would direct them to do is to apply the proper standard. Do you agree that that would be the remedy?
If this court finds that the appellate term applied the incorrect standard, then that is presumably what would happen. However, the court did not apply the incorrect
Okay,
standard.
let me ask you a question. Let's say we disagree with you on that. Can defendant raise any other grounds that weren't raised initially as a basis for reducing the sentence? Or relieving them some way of the harshness of the sentence?
The appellate term would presumably have to rely on the briefs and the record below to make a redetermination.
Okay.
The problem with that is that the defendant gave every single reason that he or the defendant had in its reasoning to reduce, and that actually brings me to my second point of why this court can be sure that the correct standard was used, because the claim was fully briefed. So the defendant gave the appellate term all of the information to determine or not determine that the sentence was unduly harsh or severe. The court did not find that. The people rebutted the defendant's claim, explaining why the sentence was not unduly harsh or severe. And it would be unreasonable to presume that the court disregarded its responsibility entirely, disregarded the law that this court has already explained, and it was recounted by both parties, and aberrantly decided to withhold discretion and halt its analysis after two mere facts.
Maybe I missed it, but they could have said, we've reviewed the grounds raised by defendant and we reject them as not providing a basis for reducing the fine.
The court could have said that, and it probably would have. However, here it did not explain, because under the CPL and under Mingo specifically by this court, the court had no reason to explain every single idea behind its decision up until that point. Now, finally, the court's prior decisions, including Carmen, it decided in 2019, confirms that the appellate term did not find either the legality of the sentence or the fact that it was fairly negotiated as a bar to reducing the sentence. In that case, the court found that the $200 fine that had been imposed against the defendant, though legal and though fairly negotiated, was in any event unduly harsh or severe. So that just happened in 2019, and one of the judges, actually the presiding judge on this panel, was on that panel, clearly not under the impression that the legality of the sentence and the negotiated aspect of it were bars to reduction. And that was very much the case here. This court's prior precedent with regard to the scope of discretion has always been permissive. So in Delgado, in Farrar and Thompson, this court found that the trial court and subsequently the intermediate courts are not barred from reducing sentences that are the result of fairly negotiated pleas. This court has never held and should not hold, it's the people's position, that a court should be barred from considering, frankly, any of the circumstances surrounding the defendant's sentence. Similarly, in Delgado, this court found that the court may exercise its discretion without deferring to the trial court. It has not held that the court cannot consider, and it has not held that a de novo review is required as in contrast to what defendant claims. If there are no further questions, I rest on the people's brief.
Thank you.
I just would like to start by focusing on the questions about what we're requesting on remand, if this case were to be remanded. So we would ask that the court be required to review all of the factors, again, employing the correct standard. And I do also believe, in response to one of the questions that was asked to opposing counsel, that briefing should be permitted again because of the fact that when this case was considered, we were working with the appellate term's current standard, which was incorrect. We were working with the appellate term's decisions, which were saying that defendant shall not now be heard to complain, and they were cited in the prosecution's brief. So I think a briefing after this, if this court were to decide that the standard was incorrect, would look differently.
Counsel, if we were to agree or approach this case the way we did in Delgado, to say this is what they meant, but it isn't what they said, and that's, hypothetically, and that wouldn't be a good thing, would that make a difference in the remedy as opposed to they applied the wrong standard?
Well, in Delgado, the cases were not remanded, and so if it were exactly the same
But let's say
analysis
now
as
we
that-
really want to lay the rule down,
Right.
say, the standard's unduly harsh, excessive. This is what you should be saying if you're saying anything, and we think that's what you meant, that's what you meant here, but you didn't say it, go back. Would that affect the proceedings below in terms of what you're saying, briefing and different arguments?
I think it would be the same, in that the briefing would nevertheless look different than what it did to the court before, because it would be a new clarified standard, and the ways in which some of the things that the appellate term were saying that were incorrect, that were being repeated in the briefing, would no longer be applied.
I assume you did brief the right standard, though.
Yes, Your Honor.
Because I was wondering the same thing. So you're just saying that the briefing might be different because had this decision held, you might have focused more on the legality of the sentence and the negotiated nature of it?
Well, I'm saying that the prosecution in their briefs to the appellate term parroted this language, cited the court that they were in front of,
Right.
which frequently says that defendants should not be heard to complain that they received the sentence that they bargained for. And so that was the language that they were using, and then in reply, we came back and said, you shouldn't use that.
So also, if you go back, if there were clarification, arguably, wouldn't it be, the argument for further briefing is that there's no further question as to whether the court applied the right standard. It had all of the information, and it could still do as it did already.
It could. The court could apply the correct standard, consider the correct factors, not consider that it was a legal or negotiated sentence, and nevertheless find that the sentence was unduly harsh. But we would certainly argue that they shouldn't.
Why doesn't it, if all we say is, we assume you applied the correct standard, why aren't you able to argue to them? I'm not saying you can, it just strikes me, I'm surprised you're not saying it. The Court of Appeals assumed this, only this panel knows, only this court knows whether or not applied the correct rule. We think it's obvious from the language it did not, and we ask you now to apply the correct rule. Here is our full briefing on the facts. They may
Yes.
not buy it, they may not agree with you, they may say, no, the Court of Appeals, of course, correctly understood us. Shame on us for not making it clear, but yes, we were applying the correct standard.
I agree that that
That'd be a
briefing would be
strategic call
necessary.
for you, I would think.
And we could make that argument. I mean, we would like the intermediate appellate court to fully consider the discretionary review
Well,
here,
otherwise, I
given
don't
that-
understand, well, I'm sorry, I'm just not clear then what the briefing part of it is. Are you saying they would change their brief, but you would not?
Oh, I believe we would change our briefing as well,
That's
for
what I'm
sure,
saying.
based on the correct standard, yes.
Okay.
Yes,
Okay.
absolutely.
Everybody gets a new
Exactly.
brief.
Yep,
Thank you.
thank you.